What's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about how to deal with debt collector lawsuits. Debt collectors who buy your debt and they take you to court to sue you over your money. This is also a response video for an individual who posted and critiqued my video about how you can fight back against third-party debt collectors. Now, for everyone, including the individual who made the video, and I'm not going to mention her name because I don't want that back and forth. I don't want any ill will to go towards anyone. I love critiques. It's like me getting into the weight room or getting into a boxing match, and it's like, hey, you take some blows and you got to get yourself back up and you got to work out even more. You got to come back even stronger, and that's what I'm doing in this video. Now, I'm not going to reveal exactly how we do this because that wouldn't be right. And if it's a person, this individual is a former debt collector, and obviously as a rep for the debt collection company, they're not going to tell you the things for your people that you're calling, how they can overcome your collection activities towards them. They're just not going to reveal that to you. And also, it just wouldn't be fair because these debt collectors, what they've been doing, because of the work that the Credit Repair Shop has been doing, and you need to like this video right now. Like this video right now because people need to hear this. Debt collectors have been making adjustments to their court summons based off of the way that we've been responding to them. So I'm going to show proof that we've won or helped people win their lawsuits. Some huge numbers. I'm going to show proof of that. So, but first, I want to, number one, these are letters from debt collectors. Resurgent, Cavalry, Discover, ARC, this is not made up stuff. We deal with this stuff every day. And when you do something every day, you start to see things a different way. You start to see openings. You start to see problems with documents that people submit, debt collectors submit, that other times, because it's just one person receiving it and they take it personal and they get emotional, they don't even understand that there could be issues with the documentation that they sent. And if a person is a debt collector that worked for a debt, or a representative worked for a debt collection company, they're not going to tell you how to help the person on the phone. They're just not going to tell you that. So what I am going to talk about, I'm going to give you some inside information on how you can fight back against debt collectors and then to respond to the individual. And also, I'm a high vibration individual. So I speak very fast. Some of the times my mind is even rolling faster than the words that come out of my mouth. But I can just tell you that this is all real. Everything I do is real. And you can go and look at my other videos where I go into more detail about fighting back against third-party debt collectors. But if you've seen my videos, you know that I'm speaking the truth on this. You know that I'm speaking the truth on this. And please like this video, put the thumbs up. We need to get more people to understand that they have a right to fight back against third-party debt collectors. So now, before I get into the proof, I want to talk about some things that I want to give you these nuggets. This is like giving you, if someone, here, I'll say it like this. When I first started doing this for other people, because I went through my experience myself back in the 90s, and I actually went up against, back then it was Roush, Israel, Hornick, and Stern. I think now it's Roush, Hornick, and Stern. They're one of the biggest debt collection companies in the nation. But they started here in Wisconsin, in Brookfield, Wisconsin, not too far from here. And they were coming after me for debt, and they said that I owed $4,500. Now, this was from a credit card that I had when I was in the United States Army. Now, let me tell you, when I was in the Army, I was only 18 years old. I went right out of high school. And the credit card that they gave me, I don't even believe that they gave me more than $500, if it was even that, for that Visa card. And because I was only making like $600 and something a month in the military. That's all I was making. That was my take home. I don't even know if I was even taking home all of that. I just don't even remember. But I did not pay the credit card. I got out of the military and forgot all about it. You know how it is when you're young. I got out when I was 20 years old. Spent 2 years in the military. Later, they came back at me and they said I owed $4,500. Years later, and I was like, what the? You know, the debt was from a whole nother state. They purchased the portfolio and came after me for $4,500. Now, this was like, at the time, I didn't know it was a lesson. But now it was a lesson because it was a lesson on something that I utilized for all of the court summons lawsuits that come after individuals. Is that there was some problems with that, but I just did not know. I wasn't educated on it. I was only probably, I think at that time, 24 years old. This is what I didn't know, is that when they buy that debt, that they have to prove everything about that debt. It's not just about statements. I'm not going to go into full detail about that, but it's not just about statements. And in a minute, I'm going to tell you exactly where you can go in the Fair Debt Collection Practices Act to prove that statements is just level one. It's just level one. Remember that. So the first thing was that it wasn't just about statements. The second thing is that the debt was past the legal statute of limitations to collect. In my research, and you can look at this, LVNV Funding Portfolio, all of these different debt collection companies have been sued by the CFPB for going after people for time-barred debt. Time-barred debt means that the debt was past the legal statute of limitations to collect. So why would they do that? Why would they risk going after debt that is past the legal statute of limitations to collect? Number one, by having their reps, like the individual who made the video, have you calling people for debts that's past the legal statute of limitations to collect. And I know what they tell you to say. They say that we're calling about a time-barred debt. That's all that's required according to the Fair Debt Collection Practices Act. So if a debt collector calls you about a debt that is past the legal statute of limitations / time-barred period, which means that there is no legal remedy for them to be able to take you to court to sue you over that debt, all they have to say on that phone call is we're calling about a time-barred debt. That's all they have to say. But before people got educated by people like me that went through stuff like this, they were taking people to court and suing them. And because people didn't either show up, they got default judgments, or they didn't even know how to fight it. They didn't even know to bring that up, to have an affirmative defense to even bring that up. And yes, we still have people to this day where they come to us and they say, I'm being sued. We look at the charge-off date. We look at the statute of limitations for their state, and it is past the legal statute of limitations for them to even be sued. But this debt collector is taking them to court to sue them. And no, they're not going to tell their rep anything about that. And here's the crazy thing about it is that they don't even tell their low-ball attorneys, the lower grade, I don't want to say low-ball, the less experienced attorneys who usually go to court because they're the ones that's just going to be sitting there, default judgment, default judgment, default judgment. The big attorneys don't go there. Even though when I did my case and I challenged the lower experienced attorney, guess who showed up? Attorney Roush. And I did the negotiations with him. And I said, okay, I don't owe $4,500. Maybe I owe $500. And I just said, I'm going to settle it for $500. I will give you $500. He tried to make me do payments for $4,500. I said, no, I don't owe that amount. Prove to me about that amount. Listen to me, that's going to be very important because I said it in words, but when you put it in writing a certain way, the judge looks at it and pays attention. But I said it in court and I said, I don't owe that amount. Prove that I owe that amount. And then all of a sudden I just said, hey, let's just go to the back, some time to talk this over, and I want to come up with a settlement because I wanted to just move forward. But I learned a lot during that quote unquote semi-trial that we had. And I ended up settling the debt for $500, but I learned that I didn't even have to pay. I could have zero. As a matter of fact, I could have flipped around and sued them because it was past the legal statute of limitations for them to collect. So now let's start talking about some gold nuggets with this stuff. When it comes to a debt collector who buys debt, Now, there's two distinguishing things, and I don't even believe the individual who made the video even knows this. But you can go and look at the Supreme Court. Justice Gorsuch wrote the ascending, whatever they call it, where they, they write and they say, hey, this is the reasons why and why we let the debt collection companies prevail with this. And probably a lot of you don't even know this. Did you know that if a third-party debt collector buys your debt, that they assume the original creditor position if they do not collect debt for other people? So if they buy the debt and they collect it for themselves, they don't send it out to someone else to collect on it, or they don't collect, or scratch that. If they buy debt and then they only collect on the debt that they buy, and they don't go and collect debt for other companies that still own the debt, where they're just where they're retained to collect on the debt. Listen to this. If they only buy debt and collect it for themselves, the key word, do not collect for others. Look it up for yourself. You don't even have to take my word on it. Just type in Justice Gorsuch debt collector decision. It says that if they collect it for themselves, they do not have to follow the FDCPA. That is why we had an explosion of third-party debt collectors where they got emboldened. But even though they got emboldened, it left the door wide open. Because if you look at the documents, when they buy the debt, they assume all responsibility for that debt. Now, in response to the individual who made the video about me, had me on that video, it was an older one, you stated that a statement would prove the debt. Let me tell you, a statement is only the first part. So this is the process. And they don't teach this to their reps because they don't want to get your mind going in the direction of helping an individual. The first step for a debt collection company to be able to sue you, they have to send a demand letter. Step one. You don't respond to that demand letter, they get to do a few things. They get to put that on your credit, and then they start to go to step two. Step two is where they're going to investigate. They're going to have their people call, their reps call, and then they're going to use skip tracing apps from like TransUnion and these different credit reporting services where they will see, how you live, the payments you're making. So they can say, this person might be worth going after in court. So then they're going to send a summons to say, okay, we're going to sue you over this debt. And they're going to put their allegations in there. And then they're going to also put the amount, and then they're going to probably put a couple of statements, if that's what they got from the original creditor. And then they're going to have all of these other documents in there. And I was thinking to myself, if it was just the statements to prove that this individual owes the debt, like the former debt collection representative stated, if it was just about that, why not just go to court with just that? No, they have to put other stuff in there. They have to put the contract. They have to do the chain of custody. But I'm not going to go into all of that detail here. You can go into my other videos about that. But they have to put a whole bunch of other stuff in there. And the reason why they put all that other stuff in there is because they want to make it look to the judge that this is open and shut, when it's not open and shut. You have so many doors that are open to you to be able to fight back against them, because it comes down to this. And I'm going to show you proof in a second that it comes down to it. And you can even utilize this for original creditors. But before I do that, let's go with my notes. Lawyers who, so I said debt collectors who collect for themselves, they don't have to abide by the Fair Debt Collection Practices Act only by the standards on what is required for debt validation. But if they take you to court, they're going to have a problem. If they collect for others, now listen to this. If they collect for others, this is the problem that they run into. And a lot of people just don't know this. But maybe you do, because there's a lot of court stuff going on right now. So did you know that if an attorney is hired or retained by another debt collection firm, that they cannot take the word of that debt collection firm with the information that they present in court? Now, they will present it, excuse me, they will present it. They will present that information in court. But if you challenge it, that attorney that is retained by the debt collection company must do their homework to make sure that everything is accurate. And if they won't get, if the original creditor or the debt collection company who retained them does not get that information to them, they will back out. They will back out because they have a responsibility. They just can't go there and be like, oh, well, you got a couple of statements. Oh, that's good enough. That's just a couple of statements. No, they have to review that. Excuse me, I'm going to take a drink of my coffee. I got my voice is running right now. So let's get into proof. Because everything that I say, everything that the other individual says, what really matters to you who are watching is that can something like this work? Because what I've learned over a period of time is that people don't want to look like a fool. They don't want to do something that's like, this would have never worked. They don't want to do something that makes them stand out like there's a spotlight on them, even though that's what debt collectors do, is that they make it like a spotlight. And Mr. Former debt collector, you know this. As soon as you get off the phone with them, you're right on the phone with somebody else. Like it's like spotlight here. Okay, now gone, spotlight here. That's the way that they make this look. And that's actually what makes people get emotional. But if you're not emotional with it and you just look at it logically, you'd be like, okay, well, you need to, what about this? What about those documents? What about what's stated in there? There are, from reviewing literally thousands of court summons, there are so many problems with the way that these debt collection companies produce these documents. Some of them you could tell that they just robo. I don't know how you robo a summons, but we're seeing that type of stuff where there was information in there that wasn't even on the information from the contract from the original creditor. Also, let me give you a quick nugget real quick. Another quick nugget. Look on the contract. We've even seen where original creditors sold debt to debt collectors and the debt collection company or the portfolio company sold it to another debt collector. And this is why, remember when it was that assigned, assumed, and all of that stuff? It states in those contracts that you cannot sell it to another debt collection company. So they'll try to use different words to say, okay, it was just assigned to them. It was just assumed to them. No, you have a right to challenge that if you see that in the contract from the original creditor. Credit One Bank is the one that does it the most. So if you had a Credit One Bank credit card and it was sold in a portfolio to a third-party debt collector, look at the contract. If they try to sue you, Credit One Bank does not allow debt collectors to assign other debt collectors to assume any debt that they sold directly to the portfolio company. The portfolio company would have to be the one that would go after the individual with debt, and it specifically states on their contract that they have to give it back. All right, so when you're fighting back against a debt collector, this is what you want to do: is you have to have an affirmative defense. Now, when you put together an affirmative defense, this is what you're doing is you're challenging everything that they said in the court summons, because you have to respond to every point in the court summons. And then you have to put together your affirmative defense. Now, one of the items that the former debt collector stated in his video was about the privacy, and that and this is just something that he hasn't seen before, but this is literally the way that we've won help people win cases when we first started was just strictly on the privacy. What debt collectors did is they went and got an adjustment to, remember all these privacy notices that come out where they make adjustments? We even saw this with hospital debt that was purchased by third-party debt collectors, is that they were making adjustments. You get that email, hey, we made to our terms and conditions, to our privacy notices, we've made these adjustments. A lot of these adjustments were made by the way that they shared the information with third parties. It doesn't even have to be a debt collector. They were just basically protecting themselves on everything, and they threw in where debt collectors, and they didn't say it with debt collectors, but they put it to where if any third party that they gave the information to, that you're signing to it. That's exactly how they did it. But we still challenge that because we want them to get the documents. Remember, when you're being sued by a third-party debt collector, they assume the responsibility of the original creditor. That means that they have to get all documents. Think about it this way. If someone buys a debt, like you're a debt collector, you're the debt collector, and you're trying to go after an individual. You buy the debt from the original creditor, and now you're going after this individual for the debt. And now you have a couple of statements. All you have is you got, maybe 4 or 5 statements. Now you go to that individual and you say, you owe this amount. Now that's where most people stop, right there. And that's why I believe the former debt collector, that's the playground, that's the box that he's in. Did you know that you have a right to say, how did that debt accumulate? Like some of a thing that I've learned over time of being in business, talking to people, dealing with my kids growing up, my 3 daughters, dealing with my 6 grandkids, is that if you ask a question and you get a response and then you ask a follow-up question, the follow-up question is where everything starts. The follow-up question is where everything starts, because most people do not even understand how to formulate a follow-up question based off of what the individual said or presented. And this is where we've been able to just destroy debt collector lawsuits, because the follow-up on the documents, and you don't even have to, like, I know that there's other people that'll be like, well, you got to state this law or this former decision and all of that. We don't even have to get into all of that. What if you could win your lawsuit based off of the documents that the debt collector presented and the lack of documentation from that they did not present? Like, if it was that's where the judge could look at that and be like, why don't you have the rest of these documents? If you assume the responsibility of this debt, why don't you have all of this information? Because if you were to go to the original creditor, let's just say you have a credit card debt, and you went to the original creditor and you said, okay, you say I owe $5,000. Maybe I owe $5,000. Can you just give me a printout of everything that I've done with you from day one? Guess what the original creditor is going to do? Okay, we'll have it to you in a few days. Punch it in, all of it's going to come out. Mr. Debt Collector or Mrs. Debt Collection Company, you say I owe $5,000. Show me all of the charges, the payments, the interest, the rewards, everything to accumulate to that amount. Guess what they're going to do? A pause for effect. That's what they're going to do. They have nothing. They have nothing. That's why they try to say all of these different things about you enriched yourself. How did I enrich myself? Look at, if you ever received a court summons, or if you got one right now, why do they say that you enriched yourself? If it was just about, hey, give me some documents, why would they even put that in there? Why would they even put that in there? because they have to build a story. So the way for you to fight back against third-party debt collectors to build your story is the affirmative defense based off of the documents that they presented and a lack of documents that they did not present. Based on the privacy. You have a right to privacy regardless if it's transferred to another company. It does just, your privacy, because you signed the document does not mean that it just gets to skip around like a kangaroo all over the place, company to company to company to company. And even if you did sign it, you still want to see it because you may not have understood what you signed, or there could be a problem with that. Maybe, and I know I wasn't going to say too much about this, but maybe that company had some issues where they got sued, or they had some, I'll just leave it at that. They had some issues where they got sued, and they had some issues with privacy, with disclosing people's private information. And now you get to utilize that in your response against them, even if it was the original creditor where they had that issue. All right, so now let's get into it. Let's talk about some cases. Let's talk about some cases real quick. Because this is how I feel about it. When you help an individual with their situation, you help them fight third-party debt collectors, you help them win. It's like you just gave them a power that they didn't even know existed. And that's another thing. When there are things that you know, there are things that you know about, and then there are things that you don't know, you don't even know. And that is what I'm gonna. That's what I'm talking about. And my brain is racing because it's just like I want to say so much, but I want to be protected from not disclosing to debt collectors who might be watching this video exactly how we fight back against them. Because that would just be like going to war and telling the enemy exactly how to fight back against you. And they are making adjustments. They're making adjustments. I'd rather have them make adjustments by the cases that they lose than just giving away the information all for free here on YouTube. So this one here, $26,000. This was from an auto debt repossession. You can watch my videos on how you fight back against third-party debt collectors who buy auto debt. That was for $26,422.54. This individual was very scared when they came to us. They were like, I can't end up having to pay this money. It's a third-party debt collector. They bought the debt. If it was the original creditor, yeah, you're going to probably have to, come to some arrangement. You can still do a settlement, but you're going to have to come to some arrangement. But it got dismissed. $26,422.54. He sent it to us. Here's another one. Dealing with the original creditor, that's American Express. I don't know if you can see that there. Cancellation of debt. Remember when I said that if a debt collector is hired retained by the original creditor, there are certain standards that they have to verify. They have to verify everything about the debt. Well, when we submitted that response, American Express, which the debt collector has a responsibility to get with their client and ask for certain stuff. For some reason, American Express just said, well, we're not even going to go after it. We're just going to submit a 1099-C, $6,327.86, $1,697.67. This is the document our client sent to us. Here's another one here. That's Calvary right there. That's Calvary. Dismissed, $1,981.88. That's Calvary. That's a third-party debt collector suing an individual for a credit card debt. So let's move forward. Let's go up to the next group. Let's go to the next group here. Here's another one, 1099-C. Can't see the amount. Here, let's do this. Let's do this. 1099-C. Cannot see the amount. I apologize for that. Cannot see the amount on there. But that is another 1099-C. And that was from a credit card company. Here's another one here. $1,335. That was a credit card debt. That was from, who do we got? Midland. That's Midland Credit Management. Here's another one here. Case dismissed. All of these got dismissed. Multiple accounts. 4,000, 20,000, 11,000. I don't even know how they came with that amount. Right there shows you that there was a problem with the documents that they had. This was Portfolio Recovery Associates. Those are our prices. Here goes some more here. Okay, this one here, 33. This was another one. This was auto debt repossession, 33. I remember this. This was a truck driver, lost his business, and but the truck was in his name. It wasn't in the business name. $33,685.13. I want you to just think in your mind, how do you think this individual felt? This person came, when you have a family, I know my mind is racing, but it makes me feel so good. So the person who made that video, thank you for making the video, because it is helping me feel even better, more invigorated. It makes me feel even more positive. It makes me want to help more people. It makes me want to help more people. Thank you, thank you, thank you. I got to do this all. I just got to do this even more. This gentleman, he's got a family. And again, we're talking about third-party debt collectors who are buying debt for pennies on the dollar. They actually buy repossession debt for a lot higher than pennies on the dollar. They can pay thousands of dollars for this debt. But let me tell you what they do. This is what they do, is that they look at what you're doing, where you're working. They skip trace. They look at are you paying any other bills? And they're like, hey, we could go at this person. We can get all that money. This is the end result here. Dismissed. I remember when he sent that over and he said, he went to court and he was like, the judge said dismissed. So now this company, they had the statements, they had the documents, they had everything that they got from the original creditor, and they lost. Here's another one here. I remember this. She's probably watching this video here. Case dismissed. She even did a text here, and she had stated that the majority of the people who came to court didn't even fight for their rights. And I just said, you have to fight. If you fight, you can win. She got her case dismissed. Let's move forward. And I have tons of these. I have tons of these. We don't even put them all up. Now, here's an interesting one here. I remember this couple. Maybe they're watching my video right now. So this was a combined one. The wife had $1,981.88, and this one was $25. So for combined, 88, $4,528.02. Let me tell you what with this one. Let me tell you with this one, what happened. Is that here's another gold nugget. Let me tell you how we fight this. I'm gonna take a quick drink. Let me take a quick drink. And I think that this one here was from above. I'm not sure, but regardless, it was a separate one. Let me tell you what happened with this one. It was a payday loan. The payday loan company, this was a direct company. This wasn't even a sold debt. Payday lender went after them in court for the debt. Now, I'm all about, if it's original creditor, hey, you got to work out something. Unless there was some problems with the original account, you can challenge it. But when we write the responses, basically to just get into a position of them potentially doing a 1099-C, potentially, or get you in a position to do a settlement. It's just where you're just not letting them steamroll over you. But when I was reviewing the documents with this particular situation, I had noticed that, and I've seen this in my state also, payday loan companies can have sky-high interest rates, but there still is a max. State to state, there is a max. The max could be 2,000%, like in my state. But this is how they can end up going over. And if they go over, all bets are off and they have just broken the law. So you go get a payday loan and then you go back in 2 weeks later when you went to do your payment, maybe you couldn't pay it off, so you rolled it over. When you roll over, what they do is they put the principal, a new principal, and you have the interest rate. When they do that, in some states, it could be over the interest rate limit for your state, and they call it usury, over the usury amount that they can charge. Now, in most states, because they've made this adjustments thanks to people like me, in most states, if you roll it over 3 times, what I've seen for most cases, that if it rolls over 3 times in the same month, automatically it has broke the interest rate usury law has been broken, because they cannot do that. They're charging illegal interest. With this one here, is what we found is that they were charging illegal interest. This one here was no, I'm sorry. This was the Calvary. This was the direct one. So it was 2546. I can't see the number on there. This is the one. So forgive me. This was Calvary, a regular credit card debt dismissed. This was the one that had the Easy Cash ASP LLC for $2,500 and some change. Here's another one here, dismissed, $28,000. You think that a debt collector is not going to do everything that they can do to be able to get $28,000? Everything that they can do to get $28,000. If everything that they gave was good enough, just a couple of statements, the contract, and the way that they want to show that they have privacy, if all of that stuff is good, why did they lose? They lost because there is ways to challenge the documents that they presented. Now let's move forward. I think we got some more on here. Here we go. All right. So we got Midland Credit Management, $4,700.49, $47.49 We have dismiss without prejudice. When they say dismiss without prejudice, they can bring it back. But this is dismissed. I don't have the amount on there. I don't know why I don't have the amount on there. And then this one here, credit card. This is one of the first ones that I did back in, I think it was 2008. Challenge Chase original. This is original creditor lawsuit, and the documentation challenged the attorney who was representing Chase. Documents could not be presented. Chase decided right here, $36,248.30 right there. When he got this document, he was very happy. Now, I know what some people are thinking. Well, if you get a 1099-C, they're going to put it on your taxes. Yes, they're going to put it on your taxes, and there's a form where you could get it waived. This individual, even though this is a person who has a business, did not have to pay taxes on the 36,248. And even if you did have to pay the taxes on the 36,248, it's going to be a lot less than $36,248.30. So I'm going to put some more on. Just last week, client call. It was a little bit over $8,000, went to court. She was very afraid. We told her, let the documents speak for themselves. Judge called her name. The judge, before any words went out, the judge just said, case dismissed. Other clients that we've helped. Even if you have a judgment against you and it was a third-party debt collector, you have a right to get that reopened if it hasn't passed a certain period of time. And that's only if you did not, we would only work with you, or I won't even say that, we would want to review it. So you can go to our to the website, thecreditrepairshop.com, in the live chat. Let us know what you've done. There's different software companies and different people out there. They're telling you to deny everything. Don't go to court saying you deny everything. Go to court challenging everything. That's how the back and forth works. And that's from experience, from me, myself being in court, and from helping other people with their situation. Now, if you need help with your credit, please go to thecreditrepairshop.com, watch the video, What Makes Us Different, so you can see my 8-point validation process and my 2-phase settlement process. There's also a link, if you go to my website, if you have a court summons that a debt collector is trying to sue you, or even the original creditor, we want to review it and we could give you your options. Even if it comes to settlement, we can help you with that. We had a doctor that came to us. She owed $59,000 and she had to get this settled. She had to get it settled. The first offer that they made her when she was working with back and forth with the debt collection company who was hired by the bank that was going after her, $59,000. They came back and said, well, we'll settle it for $55,000. $55,000. She didn't have $55,000. This was something where she had got it as into an investment and it didn't work. But she had to settle this because she's a doctor and she can't have that on her record. So something was going to have to be done, but she didn't have that amount of money. So you can imagine the emotions that was building up inside of her. Came to us, we got the communications open, we made offers, and it was a bunch of back and forth, but I'm just going to get straight to it. I need to put that one on here too. We ended up settling the whole thing for $20,000. So that's a savings over 30, what is that, 39? $39,000 in savings, and she had to pay our fee. But imagine how she felt, because it's not over her head. We even had other people come to us where they could lose their home, all types of stuff, and they need to have a settlement done. And it's hard to have a settlement between you and the debt collector and the former debt collection rep that's watching this video, hopefully still watching it. He knows that their deal, their whole thing is to try to get you emotional, try to get information out of you. And they're not focusing on a solution other than what's the best solution for the debt collector. They don't want to talk about a solution for you, to be in your favor. So if you have debt collectors that are coming after you, original creditors or third-party debt collectors that are suing you, go to my website, thecreditrepairshop.com, in the live chat. Let us know what's going on, and please upload the documents for a free review, and we will be upfront honest about what can be done if we think that you know what you can, how you can fight it. And there is no guarantee. We cannot make any guarantees on this, but we put you in the best position to win, the best position to not have a spotlight on you, the best position to allow those documents do the talking for you. If you need help with your credit, please visit thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see the way that we repair credit. And also, for a limited time, when you sign up for credit repair services, I'm going to give you my book. And this book is not about credit repair. It's about what you do with credit. It tells you how the credit system works. See, if we had this book at the beginning, people would not have bad credit. Then I would just be with my other companies. There wouldn't be any need for credit repair. No, I'm just kidding. This tells you everything you need to know about how the credit system works and how to make the system, how to have the system work for you. But you got to get your credit repaired first to be able to do that. If your credit is repaired, then you can just buy the book so you can educate yourself more about the credit system. And then I give you these 4 bonuses here. Those are going to be included. You're going to get all of that just when you sign up. For giving us a chance at helping you out with your credit, I'm going to give you that. That's a value of $59.95 right there. $59.95 value, but in all of, just when you give us a chance to work on your credit, I'm going to give you that so you can start studying. So when your credit is repaired, you're not going to run into those same problems again. The next thing is, if you need your credit reports and scores, you need the data. I call it if you want to do something, do you want to do it halfway or do you want to do it all the way? Getting all the information, all of the necessary data. There's stuff in the comments that you probably never paid attention to when it comes to debt collections, when it comes to original creditors, the words that they utilize in your credit reports, the way that they've reported. You want all of that information. I wish that it could be for free, but it's not for free. To be able to get this information, you have to pay for it. Go to the website, your3scores.com, grab your TransUnion, Equifax, Experian credit reports in all 3 scores. And then look at it, study it, make sure that everything is right. And if there's bad credit on there, do something about it. Next thing, if you have debt collectors coming after you early in the game. Remember, I stated way back in this video that I said that if a debt collector is coming after you, the first thing they have to do is send a demand letter. And then the next step is where they start calling you about the debt, but they'll send that demand letter. If you respond to that demand letter the right way, say the right things in there, it can make a lot of those debt collection companies stop coming after you, and they'll just keep going after the people who don't respond. And also, if you don't respond, like some other videos tell you don't respond to that third-party debt collection letter, they're going to be able to put that on your credit reports and start the rest of the process. I'm going to give you 3 letters. Statute of limitations letter, because you should always check the statute of limitations for your state when you get a letter from a debt collector. And the clock starts to tick when the debt charged off, not when you got the original account. You're not going to get that from the free services. You're going to get that from the service that I talked about earlier. Your3scores.com. That will have that information in there from the charge off date. That's when the clock starts to tick. If the debt is past the legal statute of limitations, there is no debt validation. All you have to do is notify them and they will stop coming after you. I have letters to prove it. Testimonials to prove it. It will happen. If the debt is not past the legal statute of limitations to collect, then you need to send them a cease and desist collection activities letter, which has some information in there, depending on if it's from a third-party debt collector who is collecting for themselves or a debt collector who is collecting on behalf of others. Remember that Supreme Court decision. But that information left the door open for you to challenge them at that point. Now, some of them may still continue. That's where you get to the next phase that I work on with court summons, but a lot of them will stop right there. And then some of them might come back, send some documents, and I give you a debt validation letter to go back and forth with them to let them know this is not going to be your ordinary debt collection case. Thank you for your time. Please subscribe to the channel, like this video, post your questions and comments. This is Stephen A.